Hello, and welcome to Your Estate Matters with your hosts, my colleague Greg Brenand and myself, Nicole Garten of Heritage Trust.
Your Estate Matters is a podcast dedicated to everything estates, including building and preserving your legacy.
If it's estate related, we'll be talking about it. We're having the conversations today that will help Canadians protect their families, their assets, and their legacies tomorrow.
Erin, thanks for being here with us today. Tell us about yourself and your journey to your current role as a partner with Clark Wilson.
Yeah, first of all, thank you so much for having me. It's my first time being on a podcast. I listen to a lot of podcasts, but excited to actually be doing one myself. I started off my career in Toronto. I'm born and raised in Toronto, and I actually articled at the now dissolved firm Heenan Blakey that you may have heard of from way back, and I was articling there while it dissolved, so that was somewhat interesting. I went to a firm that did civil and estate litigation for a few years there in Toronto. And then I moved here. And when I moved here, I really wanted to focus on estate litigation. And I took a position with Clark Wilson, well-established firm with a big estate litigation and just generally estates team. And I've been working there for coming up on 7 years now. And I'm a partner at Clark Wilson doing just estate litigation.
So tell me about your current practice and how you approach estate litigation.
Yeah, so as I said, I do just that. So I'm able to focus. Every file in estate litigation is quite unique. There's, of course, patterns you'll see, but each situation has its own intricacies. I mean, we feel like when we see wills variation claims that the same thing is coming up over and over again, or, you know, with spousal issues like we're going to talk about today, you see the same thing over and over again. But really, every client needs a very particular approach, and that's what I and my team at Clark Wilson try to focus on. Sometimes a heavy hand is needed in litigation. Sometimes a client needs to be spoken to directly about the realities of their case and the facts they've presented. I like to work with each client in their specific ways to determine realistic objectives and then to try to achieve those objectives. And sometimes that means going through the litigation process a little bit or a lot all the way. And sometimes that means other alternatives, negotiation, mediation, et cetera.
Yes, because I think just the word litigation, they always think it involves the court as the final factor, and mediation could resolve a lot of those issues.
Mediation is a wonderful tool.
Mm-hmm.
It can be a double-edged sword because there's a lot of pressure in mediation, but it is the best way to for everyone to sit down and put their full focus on this one case for the day. That goes for the lawyers too. Lawyers typically have lots of files, but when you go to mediation, you're just focusing on negotiating that one thing for that day. And there's as I've heard some senior lawyers say, and I feel this as well, there's a magic to mediation. Mm-hmm. There's a bit of a pressure cooker there. And so a lot of times you do get a settlement out of mediation for sure.
What percentage would you say of cases actually end up going to trial versus get negotiated or settled in advance?
Going all the way to trial, from what I've seen, the percentage is really low. I would call it, I haven't looked at statistics, but in my view, it's 5%, kind of a 120 kind of shot. But having said that, there are a lot of cases that might go to the eve of trial. And so you've still gone through all the preparation and expense and et cetera, and then it'll settle, just a couple days before trial. Sometimes with those, you feel like you've gone to trial, but you really haven't. But it's low that will actually go all the way to trial.
Now, as we're getting to our topic today about the spouse, who in BC is considered to be a spouse?
So we can start with the obvious one, which is if you're married, legally married, you're certainly a spouse. But I think we want to focus our attention today on the more ambiguous and the more creative one, which is, as we colloquially call them, common law spouses. To determine that, you, of course, have to start with the statute. There's the Wills, Estates, Succession Act, and it says two persons are spouses of each other for the purposes of that act if they had lived with each other in a marriage-like relationship for at least 2 years. So we have this term marriage-like relationship. That's what we have to look at, and we can break down what in the world that means, of course. But a key there is 2 years, which should be distinguished from somewhere like Ontario, where it's actually 3 years and more difficult to prove that you are a common law spouse marriage-like relationship because you have that extra year. It's a big gap there. There's no language there about gender, of course, as we could all expect. So certainly two people of the same gender can be in a marriage-like relationship. And there's also nothing in the statute that precludes a marriage-like relationship with more than one person. And in fact, in the intestacy section of that act, there is specific contemplation of someone having potentially more than one spouse when they pass away. So the big question, of course, is what is that marriage-like relationship? And you have the subjective intention of the parties to live in that relationship. And you also have the objective evidence of their lifestyle, their interactions. There's the subjective side and the objective side.
So can you tell us what some of the indicia are of a spousal relationship? Because I understand there have been some cases where people have been found to be spouses and they never actually lived together, or even at some periods of time were legally married to other people. What's the checklist that a court looks at?
Yeah, so there are a case from, it's an Ontario case from, I think it's back in 1980. It's called Miladowicz. And that sets out criteria that we still look at. It's not an exhaustive list. It's the case law specifically says it's not a checklist or anything. And so, of course, on that list, one of the things is shelter. Do they live together? But that's not required. And the court takes a very, there's cases that use words like flexible, holistic. That's the approach that the court is taking to whether someone's in a marriage-like relationship. So just to run through those factors, and some of them are things you would expect. Shelter, do they live together? That's an obvious one, and that's the first thing we probably think of because we think of that word cohabitation. Next, you have sexual and personal behavior. It's not, and there's, sexual is in the title there, but that's really not the focus. It's much more than that. It involves the behavior towards one another, their feelings. Do they eat together? Do they give each other gifts? What's their communication like? Of course, the factor of their intimacy being there makes for some interesting and uncomfortable discoveries for examination for discoveries, which I've been in, where there's I've been on both sides asking the questions and defending the questions for a client about details of their sex life, which is always something that I talk to clients about when they're getting into this type of lawsuit. I say, look, you are going to be asked about your sex life, so be ready for that. And I'm not going to be able to object to the question. It is blatantly relevant, so please be prepared. Other factors are services, what kind of domestic tasks they took on, their social life. Did they participate in community activities? How did the community see them? Their societal approach. How did they go out to the community and present themselves? And then, of course, there's a big one, which is economic support and financial arrangements. Did they have a joint bank account? How did they deal with their finances? And the last one, another very big one, but it's not often there, is children. Did they have children? Simple. Mm-hmm. Yeah. And what was their attitude towards children? So maybe they didn't have a child together, but perhaps one of them had a child that they were then raising together. That would be a factor there as well.
For the financial aspect, such thing as tax filings, is that important? How they're reporting their affairs?
I'm glad you asked that question because that seems to always come up, particularly in cases where I'm I'm on the side where we're trying to argue that someone is not a spouse, and I'll have the client saying, well, look, they reported on their taxes that they're single. It's not determinative for sure. I think that there's this perspective out there that the way you report on your taxes, whether you're single or you're in marriage, or you're in a married relationship, is all of a sudden the letter of the law. It's not that way at all. But certainly in the cases, the courts will look at that and consider it in this holistic approach. But there shouldn't be an overemphasis on it. And I feel like there is, because it's just something that's black and white. Everything else is a little more ambiguous,
Yes, I was always kind of shocked that where we would consider people not to be spouses, the person just had to fill out a statutory declaration for CPP to get spousal benefits.
Yeah,
with relatively little proof whatsoever.
Yeah, and that's of course not determinative, because you don't need much to fill that out.
No,
right?
yeah, absolutely. Yeah.
And the facts can be colorful. I think the cases O'Connor, where the purported reason why they never cohabited was she was a hoarder.
Yes.
I guess the other spouse couldn't physically move in, but then he was also legally married to someone else for part of the relationship, and the court still found them to be spouses. So the cases can be unexpected.
That can go either way, because I've seen reported cases where I think it's Glass Estate, where they were living together, but then one of them moved out because there was cockroaches and other issues in the property, perhaps a mess, which goes along with the cockroaches. And the court looked at the fact that they couldn't find a way to see eye to eye on that as a reason to find that they were not spouses, right? If your spouse, that judge thought, well, if you're spouses, then you should have found a way to compromise here. Get rid of the cockroaches, move to somewhere clean, et cetera. So it can go either way.
So Aaron, why is the issue of whether or not somebody is a spouse relevant in the estate matters in BC?
Yeah, great question. Why are we even talking about this? So when someone passes away, there's several ways that whether they have a spouse is very important to know. The first clear one is if they pass away without a will, on an intestacy, a spouse is going to have certain rights to the assets in the estate. And so determining if someone's a spouse is very key there. And as I think I mentioned earlier, the intestacy rules do specifically contemplate if someone has more than one spouse, then they can, the two or however many it is, can figure out how to divide the property, or the court is going to have to rule on it.
So Aaron, some of our listeners might not know what intestacy means.
Yes, of course. An intestacy is when you pass away without a will. So intestacy is no will. It's a legal term that is thrown around quite a bit. Yeah.
And what happens? Who determines then who receives the estate?
On an intestacy, it's laid out very clearly in the Wills, Estates, and Succession Act. There's you could call it a formula, and the spouse is certainly at the top of that formula, which is, again, why it's so important to know, is someone a spouse or aren't they? And that's where you get into lawsuits with the children, because the next in line there is children. And so these cases often come down to children from a separate relationship or a prior relationship arguing about whether later in life relationship constituted a marriage-like one. Yeah.
And can you talk about standing? Who has standing to say a will's unfair?
In will's variation, you mean? Well, that was going to be my next point about why spousal status is so important, is the only individuals that can bring a will's variation claim here in BC are spouses or children. I say here in BC because in Ontario, where there's no wills variation, but there's dependence relief, it's actually grandchildren are also able to bring that. So here it's just spouses and children. So of course, the issue of is someone a spouse is crucial to can they bring a wills variation claim? And that would be separate from intestacy, that would be a case where there is a will and you want to vary the will. It doesn't leave enough to the spouse, or to, as alleged, it doesn't leave enough. The spouse would want to bring such a claim. Yeah. Some other areas where it would be important are in the Wills, Estates, Succession Act. If someone ceases to be a spouse, then if they have a gift in the will, it would be revoked. Or if they're appointed executor in the will, it would be revoked. So you also have to look at, is someone still a spouse?
Right. So when you get into that, of course, one way to cease being a spouse is passing away. Others,
certainly
divorce, but a separating act.
Yeah.
Like if they've gone out the door and slammed it and I'm moving out.
Yeah. And that is a more complicated question, is when do people cease to be a spouse? If it's a marriage-like relationship, it's different than a legal relationship. If it's a marriage-like relationship, we look at, is the relationship, the word used is it terminated? And that is, again, the court takes a bit of a holistic approach to whether it's terminated. And there's a lot of argument in case law about what that could mean. If someone just slams the door, that might not mean a settled intention to end the relationship necessarily.
So say the relationship is terminated, but they haven't resolved their family law case. What happens if one of the spouses dies before that occurs?
The case can still certainly continue if they've started a family law case and you're on that track and there's been a termination or separation, then that case would carry on. Yeah.
Can you give us an example of how some of these issues have played out in BC estate litigation?
Yeah, I can. I wanted to mention, I was involved, it was probably 10 years ago now, in a case in Ontario. I know you said BC, but in Ontario, we went to trial about precisely one of these cases where a man was legally married to one person, but he was in a relationship as well with our client. There was a child that they were both, it wasn't his child, but they were both contributing towards. Certainly one of our witnesses, I was a first year and I was actually doing the examination of our witness who was a tutor to the child. So we were asking questions about, how is the deceased involved in your tutoring of this child. There was a house that was purchased for this person. There was certainly a sexual relationship, which was discussed extensively at discovery. And the court found that this was not a spousal relationship. Now, part of the issue there was the 3-year, as I was saying, in Ontario, you need 3 years, whereas here you need 2. So it is, I would say, much easier in BC to show a marriage-like relationship when you only need 2 years instead of 3. But that one didn't get over the hump to make it a spousal relationship. And in BC, I've dealt with a case, this one didn't go all the way to trial, but I've dealt with an interesting one where man passes away and we represent the spouse who's going to apply for probate, go about the regular steps that you do. And out of the blue, out of the woodwork, so to speak, we have a letter from a lawyer that there's this other person claiming to be a spouse who lives down in the United States. And lo and behold, they actually have a child together. So that was certainly an interesting one. Our client said they had no idea that this other person existed, that there was another relationship. As I said, it did not end up going all the way to trial. It was one of those 95% that settled. And part of the reason for the settlement was seeing that there was a child, that makes it difficult to argue that there's not a spousal relationship. If there's a child, that's a pretty big factor. Yeah.
So Greg, you've worked on cases where there were secret families, isn't that true?
Yes, certainly. We always call them like salesman cases or something like that, where somebody's traveled and or had children in other jurisdictions when they lived there earlier. But certainly 2 spouses, I've seen a few of those where somebody was married, left their spouse, was common law with somebody else, and then an unfortunate incident happened, and the question was, at that time, who is the spouse?
Exactly.
Because they were right around the 2-year mark, or just short of it.
Absolutely. Yeah.
And it's a quite complicated situation.
So there have been some high-profile BC cases recently where a spouse, it turns out there is a second spouse, and it's been quite contested about who has the ability to be executor, how the assets are going to be distributed. It's actually surprisingly not uncommon.
It seems to be more and more common. I have a few of those cases on the go where there is this argument. And the reason for that is there's a lot at stake. In an intestacy, if you, of course, you get the lion's share if you're a spouse. But also, if you're able to bring a wills variation claim and you can claim that you're the spouse, even in smaller estates in BC, if there's a property, you're typically looking at an estate that is maybe minimum $1 million or close to it. That's a lot of money. And there's a lot at stake in a lot of these cases if you are able to prove that you're a spouse. So these are...
And it's really, since our law changed here in 2014, there's no longer life interests for the spouse automatically in homes. And that's where the big fight really starts if there's uncommon children.
Right. Well, the Wills Estate Succession Act does have a section allowing a spouse to have an entitlement to a spousal home, but it's not an entitlement where they automatically get it. They'll have to pay. They'll have to pay for it out of their inheritance, essentially what they get out of the estate. Right. So that's another issue. If you have a spouse and they want to hold on to the property, you're going to have to prove that you're a spouse in order to affect those sections of the...
And with such expensive homes, it's sometimes hard to accomplish making that election for the home.
That's right. Yeah.
Right?
So we have a piece of legislation in BC, which is older, that's surprisingly not used that often, which is the Land Spouse Protection Act. So if a savvy lawyer, if a prospective spouse comes in, if the other party is the sole owner, you can file this effectively lien on title, and it creates a de facto life interest if that sole owner does pass away. Do you see that often? Or?
I haven't seen that used very much. I'm aware of it and it comes up, but I haven't seen it used a great deal.
So let's talk about predatory marriages. It seems to be increasingly common with the aging population, where there's open questions about whether the marriage itself was valid. Do you see that very often?
I do see that coming up. And it is, first of all, very difficult to show that there was something like undue influence to enter a marriage. It's also very difficult to show that there was incapacity to marry. It is notoriously understood in the estates bar that the level of capacity needed to enter a marriage is very low. It is seen as one of the lowest, if not the lowest, of all of the estate planning. If you could consider marriage estate planning, it kind of is, because it enters you into arrangements in these statutes we're talking about. But you don't need a great deal of capacity. And so, yeah, you could have, there's cases where you have caregivers in these alleged marriages, and it is difficult because of that level of capacity. The bar is low, unlike something like, a will or powers of attorney or transfers of assets, gifts. The bar is considerably higher for those. But for marriage, these predatory marriages can be very damaging to families.
So what might be the remedy? Say mom passes away and dad's caregiver secretly marries him, which is a real case that we had in our office. Like, what are some of the remedies? Would you attempt to do an annulment, or what might be some ways to attack what the family might feel was an invalid marriage?
Well, what I just mentioned is really what you're going to have to do, because clearly this individual who entered the marriage is not going to be consenting to any steps to terminate the marriage, right? So you are going to have to use the tools of showing that it was done by undue influence. So another word for that is kind of coercion to enter this marriage, or showing that they didn't have capacity to marry, which I just spoke about how difficult that is. On the undue influence point, when someone is dependent on someone else, if you can try to demonstrate that they said or that they showed or that they implied that, they would pull back their support unless you married, well, that would be proof of undue influence. But that's very hard to prove, because where are you going to get that evidence? It's probably not going to come from that caretaker themselves. They're not going to want to admit to saying something like that. And that's what makes undue influence cases so challenging.
So there was quite a well-known case in BC. I think it was even featured in the Vancouver Sun. And I think what we got from that was adults have autonomy and rights of self-determination, and they're allowed to make bad decisions. They're allowed to blow their money. They're allowed to live at risk. And I think that creates a lot of difficulty sometimes for adult children watching this. And I think that case was mom had passed away and dad met a young woman who was in a reggae band, and he purported to give all of his funds to this reggae band. And then the children were worried that he was going to try to mortgage his house to give them more money. They managed to register some sort of lien using a power of attorney. He, in fact, did try to mortgage the house, found the lien, litigation ensued. And unfortunately, the children lost. He was able to then proceed to mortgage his home and basically give the entirety of his assets to what some people might say was a predatory marriage. But the court said he had the right to make bad choices. I mean, I think, do you see cases where there's a tension between autonomy and rights to make choices of an adult and what may look like a undue influence or a coercive relationship?
I definitely see cases like that. And it's very difficult for children in that position to be watching one of their parents do these things that are seen as detrimental. But the law in BC affords a great deal of autonomy to people, interestingly, while they're still alive, yet we also have this wills variation, the ability to bring a wills variation claim here, which isn't available in most other provinces in Canada, which arguably takes away some autonomy from their estate planning.
Right. So that's actually our next question is taking in spousal considerations and planning. How about a defensive estate planning, if you're looking at that situation?
Yeah. And as I said, I do litigation. I don't do planning, but I do see these things come up all the time, and I'm well aware of them. And so some popular strategies, of course, are entering into an agreement. We hear about marriage agreements all the time. So entering into an agreement like that, where you set out that one spouse will not claim against another spouse's estate after death. Now, as you probably know, as you know, maybe not your listeners, those agreements will not prohibit or preclude a wills variation claim. And the court can still order a variation, even if you have an agreement like that. But it will be a factor, right? I mean, that agreement is telling the world this is how we wanted to arrange our affairs. And that is going to be a strong factor when the court looks at how and whether they should vary a will at all. So an agreement, even though it is not necessarily determinative of a wills variation claim and can't prevent a wills variation claim, it's powerful for sure. The other thing I see is memos or statements that go along with wills. Sometimes they're even in the will themselves that explains the deceased's decision-making in their estate, explains why they didn't want to give the spouse more, or why they only gave the spouse what they did. Sometimes it'll say something like, I gave the spouse X amount of money while we were living, like you talked about. I gave it all to her reggae band. And so I'm not, the rest of this is for my children. Again, not determinative, doesn't prevent a wills variation claim, but that's something that if it can be proven that it is true, that it contains comments that are accurate, can be a very powerful tool in the court because it's coming from the deceased's mouth in a way. And lastly, a very common strategy is, and this it should be discussed thoroughly with an estate lawyer, is transferring assets outside of your estate. That gets them those assets outside of the reach of a wills variation claim. And so some kind of basic ways to do that are putting assets into joint ownership so that a survivor will get it. That can be done with bank accounts. It can be done with property. You can also make beneficiary designations on certain types of accounts or life insurance. And lastly, there's putting assets in trust, which is something we certainly see a great deal of to avoid these types of wills variation claims and to try to plan around either a spouse or someone who you are expecting is going to claim to be a spouse.
So sometimes we see adult kids driving mom or dad to the lawyer's office with the absence of the other spouse knowing, setting up, planning those jointures or those trusts. Can that be undone using what's called fraudulent conveyance, or what are some pushbacks to that kind of planning?
So there is case law that states that fraudulent conveyance, moving assets out of your estate for the purpose of avoiding a wills variation claim, is not going to be considered a fraudulent conveyance. That is seen as legitimate estate planning the way the law stands today. And that's been pretty settled through a few cases at this point. And so the typical ways to attack that kind of estate planning are, fraudulent conveyance. If there's maybe another claim that you see that they're trying to avoid in transferring those assets, maybe there's some debt there, some debt claim that they're trying to avoid. But the common ones I'm seeing are incapacity to make those transfers. You mentioned driving the parent to the lawyer's office to do it. That fact comes up all the time. Again, it's kind of like the one you mentioned with what the tax filings say about whether they're a spouse or not. It seems to come up every time, but it's really not determinative. I mean, elderly people need rides. It's a common thing. But that's going to play into the potential undue influence case to say, well, you drove them. Were you there at the appointment? Did you bring them to the appointment? Were they the type of person that was just saying things that you told them to say? So undue influence and incapacity to try to invalidate those transfers or those trusts or what beneficiary designations, whatever have you, those are common. We see those quite frequently.
Do you have an opinion on mutual will agreements?
I think you'll have to explain what those are.
Yeah, sure. Explain them to your audience, but I don't see them coming up very much. I see them coming up in arguments that there was an agreement to have something in a will, right? But it's uncommon these days. I don't see that people are actually using it.
Well, let's maybe talk about controversies in estate litigation. So I think one controversy is whether mutual will agreements are an appropriate planning strategy. So there's a divide amongst lawyers. So some lawyers think that these are a workable strategy. So effectively, a mutual will agreement is a contract between two individuals that on the last to pass away, that the estate is going to be distributed in an agreed manner. It's often used in a blended family scenario. So blended families when they don't have mutual children. Mm-hmm. There are some practitioners that are very adverse to these, and I think they feel that it circumscribes testamentary autonomy later, that it causes other issues. And there seems to be sort of a downtown suburban divide in that sometimes the downtown lawyers won't do them and the suburban lawyers will do them. I find that interesting. So I think that's one controversy. The other controversy, I don't know, Aaron, if you want to talk about, is the whole ability to sue under the Wills Variation Act. So we used to have the Wills Variation Act of British Columbia. It was encompassed within the Wills, Estates and Succession Act, Section 60. But some lawyers, maybe the litigators, think we should have a right to vary wills, particularly if they're very unfair, maybe for cultural reasons where they're giving the whole estate to one child. But some people think that we shouldn't interfere with this and that people work hard for their money and they should be able to do what they want. Can you speak to that controversy about whether we should even have this legislation?
The wills variation legislation?
Correct.
Well, I have, I'd say, a somewhat unique perspective on it because, as I said at the top, I came from Toronto where there is no wills variation. So I was dealing in Toronto with what is similar but different, which is dependence relief, dependence support claims. And to bring one of those claims, it's similar to wills variation, but you need to show that you are dependent. You need to show that you depended on the deceased for support. So it's quite jarring to come to BC and learn. I had heard some things about this wills variation, but to come learn about it and really dive into it, now at this point in my career, I've dealt with dozens of these. And I'm not going to say one way or another if I think they should exist. I mean, I think that there is good reason for them. I think there is good place for them. I think that they are overused, and the way that the way the law is now, it seems that every child that thinks that they, sometimes even if they got an equal share, every child that thinks they can or should get a little more, why not throw out a wills variation claim, delay the estate, and you can probably get a settlement without even potentially spending too much money. A lot of these are also going to lawyers on contingency basis, and you don't have to spend any money and just try to get some settlement. That is probably, it's gotten to be a little too much, but I don't have a solution for how to stop that because, as I said, I do think that there is a place for wills variation as long as the judges uphold the other side, which is testamentary autonomy. Sometimes in the forest of wills variation, I find that we're talking about all these factors about the whole history of a child's life or a spouse's relationship and why they should get more. But what gets lost is there's still testamentary autonomy. That's still, I would say, a pillar of the law here.
Can I ask you another spicy question?
Please.
So with the advent of no-fault insurance and that there are significant numbers of former personal injury lawyers maybe looking for a new practice area, the word on the street, and I don't know if this is true or not, but that a number of these lawyers are flowing into family law, but also possibly estate litigation and just throwing cases out on contingency basis. Are you seeing an uptick in that, or is that just more an urban myth?
I am seeing a lot of wills variation cases. I can't necessarily say myself that I'm seeing more than I did, 5-6 years ago. Still seeing a great deal, and I think that has to do with, it might have to do with lawyers coming into this area, which I welcome because, I'm also defending a lot of those cases, and that's fine for me. But I think it's also what I said before, which is the law is, the cases are so permissive of these cases, even when they have very little merit. And so there is justification for these cases to just keep coming, even when there's an equal distribution, even when there's very little reason to justify a wills variation. Why not throw one out? And that's what I'm seeing. That's what I think is one of the big factors behind a lot of these cases right now.
Aaron, what would you think that some of the best practices would be to avoid ambiguity in disputes regarding spousal status in estates?
So, I mean, of course, there's the the things that I spoke about before, agreements or memos, but I mean, just having clear communications with a partner, with your lawyer, with your family about your relationships. That might all be brought up as evidence later and it might be contested, but clear communication, I think, is important. Not everyone's comfortable talking about those things, right? I mean, you get a lot of elderly parents who are not going to be wanting to talk to their children necessarily about their new girlfriend or boyfriend or spouse or partner, whatever have you. But if you're not going to communicate, you're going to have ambiguity, right? Because if you're just showing up to the Christmas dinner with someone, but you're not actually communicating about who that person is in your life, you're asking for ambiguity. Agreements, of course, provide communication to the world about your intentions. But those agreements, what they mean and their validity can be argued as well. So those are just speaking to the world, whether it's verbally or through agreements, through written means of what your relationship is. That, I think, is the best thing you can do to decrease ambiguity. And of course, going to a lawyer, right? A lawyer is always going to help you through these issues.
So those are amazing tips, although those people with secret families maybe aren't the best communicators.
No, likely not, no.
No, that's true. Yeah, that's one you're not going to get communication about.
Yes.
Any final tips, Aaron, for our listeners?
What I do see a lot is DIY, do-it-yourself, legal steps to try to avoid certain issues, and it just makes bigger problems. The most common ones, I actually mentioned this, is putting assets into joint ownership, putting property into joint ownership with a spouse without having some written agreement or discussion about how that is supposed to work. That just breeds ambiguity. So go to a lawyer that you trust more than anything. And that's the best way to avoid ambiguity and to make sure that your intentions can come to fruition after you pass.
So amazing, Aaron. How can listeners find you to learn more?
Very easily. I am at Clark Wilson. My email is apearl@cwilson.com. Clark Wilson has a robust website, of course, and my face is right there. So please feel free to contact me with any estate issues, estate litigation issues, trusts, etc.
Great. Thank you so much.
Yeah, thank you so much.
Thanks, Aaron.
This podcast is for informational purposes only and should not be considered individual legal, financial, or tax advice. Make sure to consult the advisor of your choice to advise you on your own circumstances. Thank you for joining us for this episode of Your Estate Matters. If you like this podcast, make sure to follow it on your podcast platform of choice.
Whether you are planning your own estate or you're acting as executor for somebody else's, Heritage Trust can help. Partner with Heritage Trust to protect your family, your assets, and your legacy.
If you would like more information about Heritage Trust, please visit our website at heritagetrustcompany.ca.
This podcast is produced by Podfather Creative.